Hello from the Hamad bin Khalifa University College of Law in Doha, the state of Qatar. I'm Susan Karmanian, the Dean of the HBKU College of Law. Today we are hosting our second webinar, and actually co-hosting it with the Qatar International Court and Dispute Resolution Center. It's the second one we've co-hosted together in 3 months. The first webinar, which we held in July, looked at how courts are dispensing justice in an era mainly of social distancing. Today's session looks at substantive issues. Specifically, we're going to focus on the effect of COVID-19 on commercial contracts and sovereign borrowing. Before I introduce our distinguished panel, I'd like to thank the Qatar International Court and Dispute Resolution Center for its support for this event. It is being done under a memorandum of understanding between HBKU and the Qatar International Court and Dispute Resolution Center. Our work enables us to promote learning in areas of the law that are in flux and that have a significant effect on commerce. Clearly, today's topic is important here in Qatar and around the world. I'd like to thank the president of the center, Faiza El-Sahuti, the registrar, Christopher Grout, whom you'll hear from today, and two of the judges of the center, Sir William Blair, president of the administrative tribunal, and Sean Hagan, Judge Hagan, also a member of the administrative tribunal, who will be with us today. I'd like to thank as well my colleagues at Hamad bin Khalifa University, Azzedine Abdenebi, who is in our communications department, my colleague, Professor George Dimitropoulos, who heads up our events committee, and Sandia Manas, the graduate programs and special events coordinator. Their work has made this all possible. And you're going to be introduced as well to two other panelists who have been essential to make this event come to you today, and that's Pamela McDonald and Thomas Williams. I'll introduce them in just a second. So thank you all so much for your help. And last but not least, after we've heard from our speakers, we're going to have a question and answer session. And I'm delighted that a third-year student here at the Hamad bin Khalifa University, Sheikha El-Misnad, is going to coordinate the question and answer portion of the webinar today. You're going to have a chance through your platform to participate in Q&A only by way of writing. Make sure you, in the chat function, hit all panelists, and Sheikha is collecting the questions, and we will have a chance at the end of the session to put them on the screen and have a conversation. Now that we've taken care of the housekeeping matters, I have the great pleasure of briefly introducing the panel. The limited time does not give me the opportunity to do justice to each of our distinguished speakers, but I'm just very delighted that they're able to be with us today. We will first hear from Sir William Blair, who is president of the Qatar International Court's Administrative Tribunal, and he is also president of the Financial Law and Ethics at the Center for Commercial Law Studies at Queen Mary University of London. Sir William was a High Court judge in England and Wales and judge in charge of the Commercial Court. Following Sir William will be Pamela McDonald. Pamela is a lawyer at the law firm Pinson & Masons here in Doha. Her work is in the area of construction law with a specific focus on major infrastructure projects. After hearing from Pamela, we will hear from another lawyer who's practicing here in Doha, Thomas Williams. Thomas is at the law firm of Sultan Al Abdallah and Partners. He's an English qualified barrister and heads up the Sultan Al Abdallah and Partners arbitration section. Following Thomas will be Judge Sean Hagan. Sean Hagan is a judge on the Administrative Tribunal of the court, and he currently is a visiting professor at Georgetown Law School. Judge Hagan was previously general counsel to the International Monetary Fund. After hearing the principal speakers, we'll have a chance then for some overall reflections from Christopher Grout. Christopher is the registrar of the Qatar International Court And for those of you who have been following our webinars, he participated in the webinar that we held in July on judicial process and the operations of courts. And as I said earlier, after the presentations, there will be an opportunity for questions and answers. That session will be chaired by the Hamad bin Khalifa University third-year law student in our JD program, Sheikha Al-Misnad. And as I said earlier, Sheikha will be reading the questions as they come in and compiling them. Please, throughout the course of the webinar today, feel free to hit the Q&A function, hit all panelists, and your question will be submitted, and she'll be taking a look at them and gathering those that are similar and the like. So with those brief introductions, it now gives me the great pleasure to turn the floor over to Sir William.
Well, thank you very much indeed for the very kind invitation to speak at this HBKU seminar. And if I could just make sure I can be heard. Thank you very much. I'm very grateful to Dean Karamanian and her staff and her students for having set this event up. Just one very tiny point of detail, if I may, Dean. It's the regulatory tribunal, not the administrative tribunal. We serve as the appeal tribunal from regulatory decisions.
Thank you so much. The joys of being live, and I had my notes, so thank you so much.
No, not at all.
Yeah.
And can I also say how much the QIC DRC values its link with HBKU, the College of Law. It's been great for both of us. So I'm going to talk about the effects of COVID-19 on commercial contracts. And what I'm going to do, and these remarks, of course, are of necessity short remarks, is just identify what are the main legal principles that come into play. And also because I think it may be of interest to you to mention some recent developments, particularly in cases that are coming before the courts in various different countries. But if I could start with my first slide, please. If you move to the next slide. I want to begin by putting this into context, and I hope you can read this slide. It was published a few weeks ago by the ICAO, which is the Montreal-based International Civil Aviation Organization. And to me, it very much puts this pandemic into perspective. It shows, as you can see, the estimated collapse of world passenger traffic during 2020. And as again, you can see the estimated decline is between 54% and 60%. But this is the real point I want to make about this. What is particularly revealing from the slide is to compare it with the effect of other major events over the last half century or so. So you can see that each of these crises had their effect. You've got the oil crisis of 1972, the Iran-Iraq war, a Gulf crisis, the Asian crisis, which was a financial crisis, by the way, in 1999. You've got 9/11, when passenger traffic was briefly stopped, SARS then, a few years later, and the global financial crisis of 2007, 2008. But as you can see, none of these begin to compare with the effect of COVID-19. In 2020, you see passenger numbers going over a cliff. So this is an illustration. You could take other fields of economic activity. They would show the same picture. An exception, by the way, is the valuations on the financial markets. And as you know, right now, subject to a major drop in March, these have held very steadily for now anyway. And that's because of massive injections of liquidity by various key states. But the point I want to make in opening is that when we look at the legal position, and I think this may apply to all speakers, including my good friend Sean Hagan, who will be talking about sovereign debt, we do need to keep in mind that solutions that have worked in the past may need reviewing in the future. As the managing director of the IMF, Kristalina Georgieva, put it, as the title of this slide, "A crisis like no other." And by the way, she continued, deserves a global response like no other. And one has to add that there's been no real sign of that yet. So next slide, please. I'll talk about the legal framework under three main heads, and this will come as no surprise to anybody. The effect of force majeure clauses, the effect of material adverse change and similar clauses, the possible discharge of contracts by legal doctrines such as frustration, supervening, illegality, and impossibility. But here's the point I want to make about each of these, and it's a very important one to keep in mind when you're talking about actual disputes. Under any system of law, how these principles apply is fact-specific in every case. It's intensely fact-specific in every case. So next slide, please. Let me begin with force majeure. Again, I think this will be quite familiar. Commercial contracts very often include a force majeure clause. They relieve a party from liability for non-performance caused by an event, and then you've got this familiar triple test. Was the event beyond the party's control? Could it have reasonably been foreseen at an important point when the contract was concluded? And could it have been avoided or overcome? Those are really the three gateways to force majeure. Civil law jurisdictions, including Qatar, usually include force majeure provisions in their civil codes. It's the other way around in common law jurisdictions, they normally don't. But in commercial contracts, this distinction is of limited importance, since the contractual terms are what matters and the contractual terms will prevail. So I've taken 4 examples from 4 different jurisdictions to share with you to give some indication of the kinds of things that are going on at present. And I want to start with May 2020, when the Paris Commercial Court, in a case that involved the pricing of electricity, held that there was a force majeure event because of the very sharp decline in consumption and therefore in market prices. So that's the first one. There are 4 cases in all, and the first one was decided on the 20th of May 2020. Then let me move to Egypt for my second example. It's reported that in June 2020, an administrative court in Egypt ruled that COVID-19 is a force majeure event. The particular context in that case was the suspension of an election, but it is an interesting case because it's reported to contain a reference to Sharia law. Now, so far as common law is concerned, it may be harder to establish force majeure. Why is that? So to take English law as an example, it's because force majeure clauses are construed restrictively, and the onus of proof is very much on the claimant. Why? Because the courts are keen to maintain contracts rather than see them discharged. But having said that, there's very little case law so far. But let me give you 2 examples. One is from London, where at the end of July, there was an important test case heard as to the effect of COVID-19 on business interruption insurance. Now, business interruption insurance is a huge issue because you can imagine it has the capability of a major effect on the insurance market. So there, the decision is expected sometime later this month. And then let me give you another interesting case from this time New York, and this involves litigation about co-branded credit cards. The two brands in this case were Banco Santander, Brazil, and American Airlines. Why did the litigation arise? Well, because on March the 29th of this year, American Airlines stopped flying to Brazil. I mean, if you to state that is in itself to state a pretty major thing. But if the planes aren't flying, then points are not being earned. And so that's what's given rise to that dispute. That is still at a relatively early stage. There was a decision on 21st of August, but that was on an interlocutory matter. But it does contain quite an interesting discussion of the issues. Next slide, please. So I'm not going to say too much about material adverse change. It's similar in many ways to force majeure, but it is slightly different, because when you're looking at material adverse change clauses, what you're really looking at is the balance sheet of a party. And if one contracting party has, let's say, an M&A, merger and acquisition transaction with a particular company, and its balance sheet starts to drop suddenly, then material adverse change clauses can give the party an out, and that is being argued present in quite a major case, which is in the London Commercial Court, is due to be heard at the end of this month. But the nature of the deal that the counterparty says can go off, by the way, is an acquisition by a fintech company, a financial technology company, of the business of two travel payment businesses. And you can imagine that these travel payment businesses would be solely by app and so on and so forth. So next slide, please. I know that this is of some interest in here in the Middle East, and I just wanted to say something again briefly about it. Bonds and guarantees in the context of construction contracts affected by COVID-19. We do see a mothballing of projects, we do see terminations, and we do see a rise in calls on performance and advance payment bonds issued by financial institutions, mainly banks and insurance companies. So a case here decided by the Appellate Division of the QFC Civil and Commercial Court a few months ago, Leonardo and Doha Bank Assurance Company, that it gives some interesting insights, because it emphasizes the documentary nature of these instruments. They are independent of the underlying contract. That's really the key point. They can be called on a compliant demand. Now, this case was not decided in the COVID-19 context, but you can see, and by the way, this is I'm simply expressing a view that might be put. I'm not expressing any personal view necessarily, but it could be said that applying the independence principle, the fact that the underlying contract is vitiated by some COVID-19 consideration should not in itself affect liability under bonds or first demand guarantees, and that's because of the independence principle. So next slide, please. Again, I'm not going to say too much about frustration, supervening, illegality, and impossibility. The terms really are self-explanatory. I've drawn a distinction here between the civil law and the common law. In Quebec, which is of course a civil law jurisdiction, there's quite an interesting case about payment of rent being discharged because a gym had been closed on the government orders, but that's really an example. The point is there aren't very many cases on these issues so far, but I do make the comment in the slide that at common law, this is likely to be more difficult to prove, because the common law takes quite a restrictive view of these issues. So now, the last slide, please. And these are some concluding thoughts. We're 6 months in now. Sometimes forget that it was really the beginning of March that all this started to happen. As a matter of fact, I was in Doha at the beginning of March, not since, obviously. But these are some thoughts that I simply share with you in closing. First is what I've said already, that the operation of all these doctrines depends on the facts, and it's difficult right now, really, to predict what courts and arbitral tribunals are going to find. Secondly, the issue of force majeure certificates, and that's done by chambers of commerce. And many here will be familiar with the issue of certificates by CNOOC, which is China's largest LNG importer. And the point that I make here is that this is unlikely in itself to demonstrate force majeure in law. The certificates, by the way, again, as many of you will know, were rejected by Total, Shell and Qatargas. Then thirdly, the prevailing uncertainty, which is likely to last for some time longer, is a reason why negotiation is currently the default option and is likely to stay that way for a while. But, and lastly, there is a risk of an inundation of claims in due course, which, if unchecked, could impede the recovery. And that's something I think to keep an eye on. So thank you very much.
Thank you very much, Sir William, for giving us this wonderful overview. What I enjoyed in particular was looking at it from the perspective of the common and civil law, the differences. The fact that you also looked at some of the issues relevant to the region, and also reminding us as lawyers that every case is going to be based on the specific facts. It's hard to draw out generalizations when we're looking at specific contract language and the like. So thank you so much. I will now turn the floor over to Pamela McDonald. Pamela?
Thank you very much, and thank you also for having me today. I'm very grateful to HBKU to be part of this panel. So I've been given the opportunity to speak about the effect of COVID on commercial contracts, and I should say at the outset, given that my specialism is construction, I'll deliver my thoughts through that lens, but a lot of what I'm going to say is applicable to commercial contracts generally. So I'm going to spend just 10 minutes covering it, the topic in 3 stages. I'll talk first about the immediate impact that we observed as a result of COVID, and then the medium to long-term impact. And finally, I'll talk about the negotiation stage of projects and how we're seeing that change and some of the differences pre and post-COVID in that context. So first then, when projects stop as a result of COVID, what did we see? Well, the immediate impact of COVID was, of course, felt by all members of the supply chain, all commercial parties, most obviously through the sudden unavailability of labour and resources. And consequently, the movement of materials was, and still is to some extent, disrupted and delayed. And the ability to manufacture ground to a halt in many cases. There was also the impact as a consequence of specific government action in response to the virus. So, for example, where bans were put in place at foreign ports upon the unloading of materials, for example, shipped from certain countries, or where visas couldn't be obtained for labour and staff to travel into the host country of a project. So we observed 2 broad categories of impact, the direct impact of the virus on the ability of the contracting party to honour its outbound obligations, and then the indirect impact arising from government efforts to contain the virus. More immediately, the first things parties had to consider, of course, were how they address the claims from their supply chain of force majeure and the like, as we've just heard, and on the other hand, how they pursue their own claims for additional time and money and so on. And the approach can vary from jurisdiction to jurisdiction, of course, and from contract to contract. And so as for the medium to long-term impact then, the focus here is the next phase of the impact of COVID-19, the contractual and commercial issues over the enduring medium to long-term impact of COVID. And what we're observing is parties are now recapping on the contractual status quo. They're asking themselves, where am I likely to be on strong grounds and where are my weaknesses? And they're seeking to generally preserve a back-to-back position with their supply chain, which flows their own obligations down through the supply chain. There's a real focus on delay and disruption and mitigation, and how to navigate the progress and the programme issues that the crisis is giving rise to. And more than ever, parties are aware of the importance of record keeping in all of this, to evidence the delay and disruption and the costs incurred, and to be able to question their own supply chain when they're on the receiving end of claims. And records are essential, of course, to all of that. There's also, unfortunately, the need to understand insolvency, since the cash flow tensions that were caused by the crisis will put a strain on the solvency, and there will be casualties in the supply chain. So parties are now looking at how to predict that and what to do to preemptively protect themselves, and some of the key and long-term actions in that sense. So finally then, at the negotiation stage, what we're observing really is, whilst some contracts are continuing to be procured and negotiated, in the present circumstances, we are starting to see a significant reduction in that activity on a global level. At this stage of the virus, there's not yet a sufficiently consistent approach to suggest any general market position on the issue of the pandemic and its consequences on the number of contracts being entered into, as compared to, say, this time last year. And in fact, in some jurisdictions, we're seeing no change at all in contract terms as a consequence of COVID at this point in time. That's predominantly in jurisdictions where they are now at the point of relaxing COVID-19 measures, or where there has been the least impact. But amongst those jurisdictions where there have been changes that are being observed, the picture varies. In the UK and to a lesser degree in other European countries, we are now seeing one or both parties insisting on the inclusion of specific provisions in the contract dealing with COVID and its consequences. We haven't seen anybody propose a complete express exclusion of entitlements to additional time or money, nor any agreement to that position. Where specific provisions are being included in contracts, we're typically seeing COVID being carved out of other provisions, such as the force majeure clause or the change in law clause, for example, so as to limit matters to specific provisions only. Most commonly, the supply chain and the subcontractors are requiring at least an express entitlement to extensions of contractual completion dates, and this seemingly is mostly being accepted by procurers. The supply chain is also typically insisting on an express entitlement to additional payment for at least the additional costs that they incur. We understand also that some have sought additional entitlement to recover loss of profit as a result of COVID consequences. That is being less readily accepted by procurers, and the supply chain seem more inclined to drop that requirement if it's in the context of a more immediate to short-term contract, probably because the shorter term means typically lower value, so they perceive less risk or sums at risk, or possibly because they're more confident that they can judge the more immediate future. Generally, the specific provisions on COVID are drafted so that entitlements are only linked to delays or costs that are caused by or result from, those are the contractual words we see, COVID-19 and its consequences. At the extreme end of the scale, we are hearing from some larger companies that they cannot envisage agreeing to any lump sum or fixed sum contract or completion date of any size in the near future as a result of COVID concerns and the simple inability to be able to sensibly allow for the risks of COVID and the risks that they introduce into the project. In the Middle East, then, to give it a bit of Middle Eastern flavour, since we're here in Qatar, we're advising on projects at negotiation stages at the moment in places like Saudi and the UAE and Oman and in Qatar, and in Qatar in particular in a PPP context where the funding is split public and privately funded projects. And the main risks associated with COVID, which have been problematic in our recent Middle Eastern projects, include the things that we've been hearing about: non-availability of key components since manufacturing capacity can't meet demand and scheduling proposed for the project, issues with shipment of components and movement of manpower, and of course matters regarding the management of the construction site itself, so health and safety perspective and how that's impacting projects. And lenders to these projects will need to satisfy themselves, of course, that there is adequate provision in the contract to mitigate any additional risk related to time and cost overruns associated with these types of issues. In addition to that, there are also other risk factors, of course, that are difficult to predict. For example, in Saudi Arabia recently, we saw the unexpected increase in VAT. There may also be changes in custom charges, and we're aware now that there has been a sizable increase in insurance premia in the market in the last few months too. And so, closing off for me then, key observations are that commercial parties are trying to agree as much as possible before acting, before entering into the contract. They are remaining flexible, and where the contract doesn't contain all of the answers, and often it doesn't, the key is being to keep the records and understand what happened and when and why. And with those things in mind, parties to these commercial contracts are really setting the scene to protect and enable their businesses to continue in these really trying trading environments. That's all from me then, Susan, and we'll pass over to our next speaker now. Thank you.
Great. Thank you so much, Pamela, for that wonderful overview. I thought it was interesting to think about short-term, medium-term, and long-term. And just in terms of a possible question going forward, when you talked about the COVID-19 clauses coming in, the extent to which we will look back at this 10 years from now and see it as a short-term problem, or will it have fundamentally changed things? Because the clauses going forward would protect. You look at the chart that Sir William put up in terms of the economic consequences and how significant it is. It's just something, at least that came to my mind. And for those in the audience, I hope that you're thinking along these lines. It could lead to some additional questions in our Q&A. I'd now like to turn the floor over to Thomas Williams, who I understand is going to give us some additional perspectives on force majeure Qatar, and also on some of the dispute resolution related issues, particularly perhaps even in the arbitration context. So Thomas, the floor is yours. Thank you.
Susan, thank you, and good afternoon, everyone. It's a great pleasure to be taking part in this webinar. I'm going to be talking about two things. First of all, Qatari law aspects of COVID-19, in particular looking at force majeure and related concepts, and like Pamela, looking at that through the lens of construction law. And then the second thing I'm going to be looking at is how international arbitration has responded to the pandemic. Now, starting with the Qatari law aspects of things, the law is often viewed very much as theoretical and abstract, but I think when it comes to force majeure, it's of enormous practical application and importance, and that's no more so than in the COVID situation. As Sir William Blair noted in his very helpful first slide, the impact of COVID-19 on the world has been absolutely catastrophic, really, and Qatar has suffered significantly. In terms of specific impacts, as we know, travel has been very much restricted in and out of the country. So many things have been closed. We've seen the metro shut down, schools, malls, hospitals, the industrial area where so many construction workers live and where so much construction material is kept. So it's hardly surprising that contractors are saying, look, I can't perform because performance has been made impossible by an unforeseeable event beyond my reasonable control. And that, in a nutshell, is what force majeure is all about. Now, as Sir William noted, there are two routes that you can pray in aid force majeure. One is by a force majeure clause in your contract, and or as a result of how force majeure appears in the civil code. Now, as for force majeure clauses in your contract, project managers and lawyers, contract managers, should review the terms of their existing contracts, both up and down the line with employers and main contractors, and down the line with subcontractors. And for each contract, they need to ask themselves a number of questions. Does the force majeure provision require performance to be impossible? Do the COVID-19 implications fit into the scenarios prescribed? For instance, does the word pandemic feature? Is notice required to be served? And if so, when does notice need to be served? Does it give the contractor time and money, or just time? When is the suspension provision triggered? And when is the termination provision engaged? And is a notice and court order required? In terms of the civil code and how that deals with force majeure and related concepts, I think it's helpful to see the way that the civil code treats all this in terms of what I would call force majeure proper on the one hand and force majeure light on the other. And force majeure proper is all about impossibility of performance. And the Civil Code gives voice to that concept in Articles 187 and 188 of the Civil Code. And it might be helpful to those listening if I just read out those articles. They're pretty short and pithy and I think easy to understand. So Article 187 provides as follows. In contracts that are binding on one side, if the execution of the obligation becomes impossible for some external reason in which the debtor played no part, the contract is automatically annulled. If the impossibility is partial, the creditor may hold to the contract in relation to what remains of the obligation that can be executed. So that's Article 187. Article 188 provides as follows. In contracts that are binding on both sides, if the execution of the obligation of one of the parties to the contract becomes impossible for some external reason in which he played no part, this obligation terminates, and the obligations that correspond to it terminate with it, and the contract is annulled automatically. If the impossibility is partial, the creditor, according to the circumstances, may hold to the contract in relation to what remains of the obligation that can be executed, or may apply for annulment of the contract. So that is what I would call force majeure proper. Now, moving on to force majeure light. And what force majeure light is all about is where the circumstances are such that performance falls short of impossible but it's very much harder for you to perform. And in circumstances such as that, the Civil Code offers relief, and it does so through Article 171, which talks about burdensome obligations. Article 1711 just deals with the primacy of the contract as the legislation between the parties. But Article 1712 brings in this notion of burdensome performance. So notwithstanding the fact that you've agreed to do something, Article 1711, Article 1712 might come to your help. And that provides as follows. Nevertheless, if general exceptional events occur that it was not possible to anticipate, and the consequence of their occurrence is that execution of the contractual obligation, even if it does not become impossible, yet becomes burdensome to the debtor, such that it threatens him with massive loss, the judge, or for that, read the arbitrator too, in accordance with the circumstances, and after balancing the interests of the two parties, may restore the burdensome obligation to a reasonable level. Any agreement to the contrary is null and void. So you can't contract out of that provision. It's there. It's important, though, all that said, to bear in mind what Article 700 of the Civil Code says. And it says this: without prejudice to the provisions of paragraph 2 of Article 171, which we've just been looking at, any increase in the prices of the primary materials and wages of the workforce and other costs will not affect the extent of the obligations arising under the contract. On the subject of force majeure light, we also have to look at Article 256. If the debtor does not execute the obligation in kind or delays in executing it, he is obliged to pay compensation for the detriment sustained by the creditor, unless he proves that failure to execute or delay in execution was for an external cause in which he played no part. So that is just a very quick canter through some of the main provisions which are in point when considering impossibility of performance or unduly burdensome performance. As Susan said, I'm now going to talk, if I may, just a little bit about how I think international arbitration has coped in the context of COVID-19. And I'd like to hear the other panelists' views and indeed the audience's views on this. But I think that in general, international arbitration has responded very well. And I'm not sure that we should be too surprised about that, because all of the issues which COVID-19 imposes on the world, such as keeping people apart, such that it's got to do things remotely, is something which is bread and butter in terms of logistics for those of us who practice in international arbitration. We're well used, aren't we, to conducting hearings over the telephone or by video link, by email and so on. The only exception to all of that are final or evidentiary hearings, where we are very much used to sitting in one room. And we all know the obvious advantages of that. Advocacy has much greater impact if you're actually in the room with the decision maker. Likewise, when you're cross-examining a witness, it's much more impactful if you're there, just across the table from them. And it's much easier for the arbitrator to gauge the credibility of evidence if it can actually see in real time the demeanour of a witness. So I'm not saying that it's not without its difficulties and challenges, but by and large, I think that we're all used to dealing with things as they now are, because really we've always done it that way. And I think the only real issue is with regard to final or evidentiary hearings and the necessary limits which are entailed by them. I think something that's really well worth people having a look at, and it's something that I came to relatively recently, is the Seoul Protocol on video conferencing in international arbitration. It's really excellent. It was drafted by the Korean Commercial Arbitration Board. I was unable to find the date on which it was promulgated, but it's as recent, I think, as this year. And it contains a number of very interesting provisions, which, if adopted, I think, will be of help, certainly in the present circumstances. I talked about the potential difficulties in terms of the examination of witnesses. Now, Article 1 of the SOL Protocol addresses this, and it has some quite interesting observations to make in terms of what it would require if the parties adopted it. And I just might read a couple of the provisions. The video conferencing system at the venue shall allow a reasonable part of the interior of the room in which the witness is located to be shown on screen, while retaining sufficient proximity to clearly depict the witness. Secondly, the witness shall give his or her evidence sitting at an empty desk or standing at a lectern, and the witness's face shall be clearly visible. So I think all of that is common sense, but it would certainly help. And if you adopted this protocol, it's the way it would have to be done. And I think that's helpful. In terms of documents, I've heard a number of practitioners say, well, the problem with having evidence being given in a room, separate from maybe counsel and the arbitrator, quite apart from the arbitrator's ability to gauge credibility, is the fact that you don't really know whether the witness has got a crib sheet. You're very much trusting as to what the witness has got in front of him or her. And Article 4 of the SOL Protocol says this about that particular issue. The party whose witness is giving evidence by video conference shall provide an unmarked copy without any annotation, notes or markups of the agreed bundle of documents, or such volumes of the agreed bundle of documents as the parties agree or are required at the start of the examination of the witness. So I think those two aspects of the SOL Protocol are a particular issue, but in general I would commend this as quite a useful thing for parties to bear in mind as adopting a soft law. Locally, I think that people have coped very well in terms of arbitrations. Our local arbitration institution, KICA, has been very responsive to the need to do things remotely and with technology generally. And I know that the International Court has been commended for doing that as well. So I think that as a jurisdiction, we're doing very well in responding to the great limitations imposed on us. And with that, I will finish my presentation. Thank you.
Thank you so much, Thomas, for giving us first the substantive principles under the code. I know some of the students here are studying the code, and it was a good way to walk through the language, and also to touch on some of the procedural issues relating to arbitration, particularly the ability to act quickly in the challenges associated with that in this constrained environment. Now we're going to pass the floor over to Judge Sean Hagan. And Sean, as I should have said earlier, is a judge on the QFC Regulatory Tribunal. Good morning, Sean, from Washington, D.C. It's a great pleasure to have you with us. And his remarks are going to start looking a little bit on outside of just business to business, a lot of commercial, and the issue of sovereign borrowing. So, Judge Hagan, the floor is yours.
So thank you, Professor Karamanian, and welcome. I'm sorry that I was late joining this. I was finishing a class at Georgetown, which is also being done virtually as well. So, but anyway, I'm excited to be here and to join this group. As Professor Karamanian has said, I'm going to be talking about sovereign debt. In other words, debt incurred by governments. And as you all know, all countries are suffering as a result of the pandemic. But I think there's a recognition that there's a particular strain being placed on developing countries, both emerging market countries and low-income countries, for a variety of reasons, partly because of the fragility of their healthcare systems, but also because of the economic impact. They don't have the capacity, like many advanced countries, to basically throw a tremendous amount of liquidity from the central bank. And there's a real concern that these countries are going to go through a very intense and prolonged economic downturn. And in particular, of particular concern is what will happen to the debt that they incurred prior to the crises. Okay? And you will not be surprised to know that governments borrow money internationally. And actually, that's not a bad thing. It's a good thing because they can use the proceeds of their borrowing to finance very worthwhile projects, including development projects, in their own countries. But they can get into trouble as a result of that. And the concern is that the pandemic is going to get them into serious trouble. So what I would like to do is to talk a little bit about what generally happens when you have a country that has what we call debt distress, and then specifically some of the issues that may arise in the context of the pandemic, including a range of legal issues. Okay? So, as I've indicated, for the last 40 or 50 years, governments have taken advantage of the globalization of capital markets to borrow from private individuals, bondholders, banks, and these creditors are happy to do so because they can often get a higher rate of return than they would otherwise if they were lending in their own countries. So it's a potentially win-win situation for both the country and for the creditors. The problem arises when, like everything else in life, where there's too much of a good thing, where governments become somewhat reliant on the borrowing. And there's a pattern that often ends up happening where governments borrow quite a bit internationally, and they end up repaying their debt, not by generating the foreign exchange through their exports, but by borrowing. They borrow to repay. In other words, they refinance their debt. Okay? And the risk with that is if the international community begins to believe that there are problems in your country and that you may have a long-term issue with your repayment, they may no longer be willing to lend to you. And that means that you can no longer service your debt. Okay? So you're at the mercy of the perception of the market. All right? And unfortunately, market perceptions are very fickle and very psychological. And they can go through huge swings in confidence. And sometimes, and this is what's so tragic for many countries, is that they may decide not to provide financing anymore, not because of something that's happened in that country, but because of something that's going on in their own country. In other words, there could be what's referred to as an exogenous shock, where the market pulls back because of a global event. And sometimes the events are also local. You can have a change in government where the new governmental leaders announce policies that creditors have a very hard time with. And we've seen that. But often it's an exogenous shock. And when that happens, the country is brought to the brink of default. because it can no longer borrow to repay. And what it does is it goes to the lender of last resort, which is the International Monetary Fund, which was set up precisely to provide financing, foreign exchange to countries that can't find it anywhere else because they've lost market access. And when the IMF lends, and the IMF is there for this reason, and the IMF will gladly give the country the money to repay its creditors. However, there are some strings attached. Surprise, surprise. And essentially, the IMF requires the country to adopt changes to its policies that will effectively enable it to be more independent. You know, get its household in order so that it can no longer be addicted to debt as much, to pull its belt, to become a bit more economically responsible. All right? And normally that works fine. But there are many times where the IMF says that's not enough. This debt has become so significant that the only way out of this problem is there needs to be a reduction in the debt. Creditors have to absorb some of the pain too, and there will need to be a debt restructuring. Okay? And it would be the IMF that makes the judgment. Can we repay the creditors under the original terms, or does there have to be a debt restructuring? Okay? So that's the overall architecture that exists. Now, the pandemic. Well, the pandemic is the classic exogenous shock. It's not only the classic, it's an exogenous shock on steroids because it has affected the entire global economy. And as a result, creditors are not providing financing to emerging markets. They're doing it for a variety of reasons. First of all, they correctly see that emerging markets are going to go through a downturn. But secondly, they are experiencing losses themselves back in the United States or back in the UK, where many of them are located, because of the crisis in those countries. And as a result, in April and May of this year, when the stock market collapsed, there was a huge, essentially, outflow of capital from emerging markets and low income. In other words, essentially, there was no longer finance being provided by creditors to sovereigns. And sovereigns were at the brink of default. And they all came to the IMF. And the IMF provided an initial round of financing to these countries to help them repay without asking for any debt restructuring. Why? Well, because the IMF wasn't sure. Is this a case where this is going to be a recovery and we won't have to restructure the debt? Or are we going to have to restructure the debt? The IMF basically gave the country the benefit of the doubt, the creditors the benefit of the doubt, and effectively provided financing to many of these countries initially without there being any debt restructuring. However, there is a growing concern that this is not a V-shaped recovery, that we have an extended period of economic decline, and that economic decline is going to hit emerging market and low-income countries in particular. Why? Well, let's start off with the fact that if the pandemic really continues to spread in many of these countries, the emerging market countries, they're going to need to devote resources to helping their population, not to repay the debt. So the idea that the debt cannot be repaid is going to become more and more important. Secondly, their capacity to export, to generate the foreign exchange to repay the debt is going to be undermined because the advanced economies are going through a recession. So their export markets are shrinking. So there's a tremendous uncertainty right now as to whether or not we can get through this crisis without there being a major restructuring. And quite frankly, there are those both at the IMF, the World Bank, and elsewhere that are planning for what we call a systemic debt crisis, which is a crisis where a significant number of emerging market and low-income countries have to restructure the debt. The last time we had this was in the 1980s. Some of you may remember there was a major debt crisis in the 1980s involving almost all of Latin America and some Asian countries. And there's a fear that we are going to be facing this within the next year. And there is a discussion about how we will restructure the debt, which brings me to the legal issues, which is when you talk about the restructuring of debt of a corporation or of a bank or even of an individual, you know your domestic legal systems, there is a legislative framework that guides that process. There's an insolvency law, and these insolvency laws either provide for liquidation or debt restructurings or rehabilitation, right? Chapter 11, or in the UK, a scheme of arrangement. Well, the sovereign debt is the one type of debt where there is no legislative process. There is no legislative process. There is no international bankruptcy court that guides the restructuring of sovereign debt. That determines when there should be a debt restructuring and how much and how you bind creditors to that process. And in some respects, the IMF has become the insolvency court de facto in terms of determining when it will happen. But one thing the IMF cannot do is bind creditors to a restructuring agreement. You know how insolvency laws work. When a majority of creditors have reached an agreement with the debtor, it will take that agreement to the court, and the court will make it binding on all creditors, including what we call holdout creditors. And there is no such legislative framework to deal with holdout creditors. This was never a problem in the first systemic crisis, Latin American debt crisis. Why is that? Well, we did not have a lot of holdouts. Why? Because they were all banks. We had about 15, 20 banks. They all got together around a big conference table and more or less they agreed. And if they didn't agree, the central bank would twist their ears and say, agree. And generally it was done. Now, most of the creditors are bondholders. And bondholders are not subject to the influence of central banks. There are many of them, thousands of them, hundreds of thousands of them in different jurisdictions, holding instruments governed by different laws, subject to the jurisdiction of different courts. So there is a real concern that the ability of a country to restructure its debt and make it binding on holdout creditors is going to be under tremendous stress. Now, there have been some workarounds that have been introduced. For example, introducing clauses in bond contracts that enable a qualified majority of creditors to make an agreement binding on the holders of that contract. And there's been also clauses that try to link different bond issuances to aggregate voting. And this is being tested right now, actually, in the case of the restructuring of Argentina's debt and Ecuador's debt as we speak. In fact, the deal closed yesterday. But there's a concern that if we have a systemic crisis, this is not going to be enough. We may need to look at a legislative framework. Now, we're not going to be able to come up with a new treaty to do this in time for the pandemic, right? I mean, you know, treaties, negotiating a bankruptcy treaty, because it would have to be a treaty binding on all countries in the context of a pandemic, is a joke, because it would take 3 to 5 years, and by that time, you know, the damage has been done. So there is discussion about, is there anything on the table right now that we could pull off the shelf? And I'm going to leave you with 2 thoughts. One is, and you're going to think this is kind of crazy, but it was used before, the UN Security Council. The UN Security Council has the authority under Chapter 7 of adopting resolutions that are binding on countries. And during the Iraq War, or just after the Iraq War, when Iraq was restructuring its debt, the UN Security Council adopted a resolution that immunized Iraq's assets from attachment. And that essentially dealt a blow to any holdout creditors. So there's a question. Would it not be feasible, if in fact this pandemic becomes systemic, for the Security Council to adopt a resolution that would have the same effect, at least for those countries that qualify? Another one was in the UK. The UK adopted legislation that basically also immunized the assets of certain low-income countries that were going through debt relief from the IMF about 20 years ago. Now, the UK could adopt similar legislation. And why would that be so important? If the UK does it, but that's just the UK, but what about all the other countries? Well, the reason why the UK is important, and I'll finish here, is because 90% of low-income debt is essentially under contracts that are governed by UK law, and where the UK is the jurisdiction. So there is a possibility that, at least for the low-income debt, not for all emerging market debt, that the UK could adopt such legislation. And I've written a couple of articles about this that make these proposals. Whether or not any of them see the light of day is another story, but I would leave you with that. Thank you, Professor.
Thank you so much, Sean. I would like to say for those uplifting remarks, but it's very enlightening in terms of not just what we've been looking at before on the commercial side, but the significance of this in the realm of countries and the role IMF, or the lack of capacity to perhaps deal with this situation. I had a question I had for you comparing this to other situations of severity, but you answered it in terms of the exogenous shock on steroids. So, Christopher, would you like to chime in, just give some reflections, and then we'll open the floor for our questions and answers.
Yes, well, thank you, Susan, and good afternoon to everyone, or good morning, depending upon where you're viewing from. I just want to make a few short observations in relation to dispute resolution in the time of COVID. And it seems to me that there are basically 2 issues that courts and other dispute resolution bodies need to bear in mind. One is the resolution of disputes that arise either as a direct or indirect result of the coronavirus pandemic. And some of the other speakers have highlighted some of the issues that may arise in the future arising out of such disputes. But the second is the facilitation of resolving disputes generally during the time of coronavirus and the pandemic, because what's really important, systems don't grind to a halt when it comes to the resolution of the disputes that continue to take place, notwithstanding coronavirus and the pandemic. And one of the things that I talked about at length on the last webinar that we did was how the courts, particularly the Qatar International Court, have continued to function in light of the pandemic and the issues that have arisen. I don't want to repeat those observations again, but what I do want to do is to address some of the points that was made by Thomas in relation to evidentiary hearings and concerns that have been expressed about witness testimony. Because I have had some experience now, both here and in the United Kingdom, of dealing with witness evidence remotely. And I think it's important to recognize, but also address some of the concerns that have been raised about how disputes that involve witness evidence are facilitated when dealing with cases virtually or remotely. And there are two broad issues. One is practical concerns relating to witnesses, and the other is concerns about the quality of the evidence that they're giving and whether or not the quality is being diminished as a result of conducting a hearing remotely or virtually. Practical concerns, the good thing about them is that they can usually be easily addressed, providing that you put planning in place prior to the hearing itself. Because things like ensuring that the witness has the correct audio video technology, ensuring that they're speaking from an appropriate room, ensuring that they don't have other people who can influence them in that room, can all be dealt with by way of simple ground rules that the court can issue in advance of any hearing. And that's what we do here. We issue ground rules to the parties and the witnesses that they must follow in order to participate. Things like ensuring that witnesses can take oaths. The witnesses will need to make sure that they have access to the appropriate form of wording in any holy book that they may wish to give evidence on. But the point is, these are all practical issues that can be easily resolved, providing the court or the arbitral tribunal, as the case may be, addresses them in advance and doesn't leave them to the last minute. I think the real concern is the one that Thomas highlighted about whether or not the credibility of witnesses or the demeanor of witnesses can be appropriately assessed when they're giving evidence virtually. And my own view, for what it's worth, is that sometimes the concerns about not being able to assess credibility and demeanor remotely are perhaps overstated. Because at the end of the day, as long as the technology that you're using is good enough to be able to see and hear the witness clearly, then really, are you in any different position from having the witness in front of you in a hearing? And let's face it, in most commercial cases, most of the issues are documentary. There will be cases from time to time that rely on the resolution of disputed issues of fact that require witnesses to give evidence. But largely, disputes are document-driven in a commercial setting. Those observations may not necessarily be appropriate in relation to criminal trials and family cases, but there are other unique concerns, I think, when it comes to those sorts of matters. One observation I would like to conclude on, if I may, is the importance of assisting people who are particularly vulnerable as a result of the COVID-19 situation. And one of the things that we did earlier this year is launch a pro bono service to help those people who were adversely affected, not only by the coronavirus pandemic, but for other reasons, are financially unable to afford legal representation. And so we launched a scheme to assist those people who have disputes that fall within the jurisdiction of the Qatar International Court and the Regulatory Tribunal, but who are genuinely unable to pay for legal representation. And I'm pleased to say that a number of lawyers, both in the Qatar Financial Centre and in the state of Qatar more broadly, have assisted us in joining that scheme to provide free legal advice and representation to those in need. And I'm also particularly grateful to the Dean of the College of Law at HBKU, because she has kindly allowed her faculty and staff to assist the lawyers with legal research in appropriate cases. And the key point I want to end on is that these issues are important to bear in mind, because we know that there's a risk that disputes are going to rise as a result of the current situation. We want to make sure that access to justice is maintained, and in particular, we want to make sure that the most vulnerable people in society are not marginalized, and that they do have access to a lawyer, and that they do have access to the courts. And so, speaking on behalf of the Qatar International Court, I'm particularly grateful to all those people who have assisted in ensuring that that's possible. So thank you very much.
Thank you very much, Christopher. And your remarks really remind me that, you know, that we have a title of commerce and sovereign borrowings, but it's all about individuals. And I think clearly when we heard Sean speak in terms of entire countries being vulnerable, and then of course we've heard about delays and payments and the like, individuals are hurting substantially, and keeping that in our mind every time we act is something I think that's absolutely critical. So I would like to thank each of the speakers for the wonderful presentations. We've covered a lot in very short time. I'd like to now pass the floor over to Sheikha El-Misnad, our third-year student. And Sheikha, have we had any questions come through?
Yes, hello everyone. I'm Sheikha, and I've been looking through a lot of the questions that you've sent in. Thank you very much. And I'll share some now. The first question that we received was, as COVID-19 is a given now, will force majeure be applicable in future contracts? And I think what it's saying is, if COVID is now the new normal, how can we use force majeure as a clause in future contracts, and will it be applicable? I think one of the first people to speak about this was Sir William Blair, if you would like to touch a little bit on this subject.
Well, thanks, Sheikha, very, very much. And thank you for doing the Q&A. I think it's going to make a huge difference because in the future, people are going to be much more careful about what they put into their contracts. It really, I guess, but might cut both ways. You can't say anymore that a pandemic is unexpected. Do you see what I mean? Because we've had one. On the other hand, we've seen the effects of it, and you know, each of the speakers has made it clear how kind of global this is and how it affects everything. So what I think you'll find is much more detailed care in drafting these clauses to try and make them fit the kind of experiences we've had this time.
Thank you very much. Thank you.
No, I absolutely agree with what Sir William has said. I also think that just because you might not be able to rely on impossibility of performance in these circumstances, it might mean that you can still rely on the fact that the contractual obligation is unduly burdensome for existing contracts. I think if you're starting from scratch now in circumstances where you know how it's going to be to perform, as Sir William says, you've really got to start from a blank slate and start explaining how you're going to perform in the new normal.
Yes, thank you very much. That makes a lot of sense, actually. It's something that's new to everyone, and we're all going through it together.
Yeah,
so,
and I'd also add that, of course, it's implied into every contract that a contract has to be performed in accordance with the duty of good faith.
yes.
So if somebody does find that a contract is difficult, notwithstanding the fact that it's been drafted to meet the current situation, they can't behave in a way which is contrary to the obligation of good faith. And so if somebody is finding it difficult to perform, then you have to take that into account when exercising your own rights. And we've seen that time and time again.
Yes. Thank you so much, Sir William Blair and Mr. Thomas Williams. Our second question is related to construction contracts, and it says that, do you think that the lump sum construction costs will go up due to the COVID-19 pandemic? And I think this is very clearly aimed at Ms. Pamela McDonald.
Thank you. Thank you. That's a good question. I think inevitably it will in the short to medium term, in response to the fact that construction sites are different now. We have, for example, for labourers and staff, staggered start times. There have been new staff members introduced to ensure COVID compliance, and the health and safety factors that introduce new costs and so on. And the contractors are now also starting to look to technology to help them in the pandemic. And all of that costs money, of course. So I certainly think that in the short to medium term, contractors will be trying to negotiate a higher lump sum for construction projects. But of course, it is still competitive out there. Qatar is particularly competitive a market for contractors, and that really does drive costs down. So I think generally, if all of the contractors acting together are driving costs up, then it will go up. But subject to those individual contractors who are willing to go in very low to win the job, that there may be some fluctuation.
Okay, thank you very much, Ms. Kamal. I think it's the next question kind of relates to what everyone has been discussing today in this webinar, and it's, are there some big lessons in terms of contract drafting that we have learned, and if so, what are they? A couple of the audience members have been very interested in this when it comes to the construction contracts, as well as when it comes to force majeure. Should they have more specific clauses, or how can they better protect? And I think I'd like to start with Mr. Thomas Williams, if you'd like to touch on this subject, and then we can move on to analysis.
Well, I think it's important to have robust force majeure clauses in there, which might expressly refer to COVID-19 or pandemic-like issues such as that, and also have express reference to what I would call force majeure light, so that if performance becomes unduly burdensome, you can take advantage of the civil code provisions that give you relief in those circumstances.
Thank you, Mr. Williams. Would anyone else like to share their thoughts regarding this question? How can contracts, or how can drafting contracts be improved during this pandemic? Or what lessons have you learned from drafting contracts?
I might just add, at the risk of repeating what I already mentioned, that the main takeaways for us as a business globally are that the construction contracts are being drafted differently. Whilst force majeure provisions will of course remain in there, they will be closely scrutinised, and in many cases we are seeing COVID being carved out of those typical provisions and taken as express provisions, dealt with in a lot of detail, what it means and what the consequences are of it, and taken out of the change in law clauses as well. Because of course, as construction lawyers, we try to include everything in a contract, but we can't foresee everything. And that's why we have a force majeure provision, of course. But this COVID pandemic is something known now. So in our experience, we're extracting it out of those catch-all type provisions like force majeure and change in law.
Thank you very much. We have a lot of questions, so I'll share now the next few questions. The question number 4 says, do the bond agreements have arbitration clauses, or are there BITs that could cover them? I think this is aimed at Judge Hagan, specifically regarding when you were talking about bonds. Would you like to share your thoughts regarding this question, please?
So bonds entered into between sovereign countries and creditors generally do not have arbitration provisions. They basically are subject to the court's jurisdiction. However, bilateral investment treaties entered into between countries may be applicable by virtue of the fact that the investments that are covered under those bilateral investment treaties, although they are primarily intended to include foreign direct investment, actually are broad enough to include the indebtedness of a sovereign. And as a result of that, there has indeed been litigation arising from defaults on sovereign debt under ICSID. In other words, to the extent to which the bilateral investment treaty provided for ICSID to have jurisdiction, basically the panel of ICSID arbitrators have had jurisdiction in these disputes. And the most well-known example of that is Argentina. Argentina, in some respects, always gives its body to science when it comes to sovereign debt, because it has been involved in so many debt restructurings that so much of the law that we have involves Argentina. And there has been ICSID litigation involving basically defaults under Argentine debt. So you do have arbitration, but it's through the bilateral investment treaties that confer jurisdiction on ICSID.
Okay, thank you very much.
Perhaps I could just add to that, because I've sat as an ICSID arbitrator myself, but also as a judge, and a lot, as Sean Hagan has said, of sovereign debt is issued under New York law or under English law. It's not really UK law, it's specifically English law. And this has brought all kinds of cases to our courts, Sheikha. And they're very often in the context of enforcement. So the dispute will really not be as to whether the debt is owing or not, because if you have a contract, say a project contract or something of the kind, or sale of goods contract, the dispute is very often, well, has the contract been properly performed? Very often these cases are coming to the courts, not with the question of, well, is the debt due or not, or has the debt been repaid or not, because the answer to that is probably no, but in terms of enforcement. I mean, there are some, as Sean Hagan knows very well, there are some exceptional cases that are either going up the courts or have got to the senior courts and waiting for clarification. But his point, I think, really, it was a valuable question, but I think his point really is that whatever you do on dispute resolution, you've got a major problem, which you can't really solve through dispute resolution. Dispute resolution will solve particular sovereign debt issues, or solve a particular dispute, but it won't resolve a systemic one. And for that, you need the global community. And if I could just draw together the two lines of discussion in this webinar, commercial contracts on the one hand, and sovereign debt on the other. What they have in common is that the effects of them are capable of spilling out onto the whole global arena, and that's why you've got to take this global view. Thanks.
Great, thank you so much, Sheikha, for leading this Q&A, and thank you so much, Sir William Blair, for tying this together. We heard about the human aspect of it, but again, the global dimensions to this and the need to have a global resolution. And as Sean Hagan reminded us, the challenges of doing that in this current environment, and that's a challenge that has existed in some of the other crises that he described as well. We are nearing, or we are at the end of the session. I would again like to thank the Qatar International Court for co-sponsoring this wonderful forum. Thank you so much to the audience, and I'd like to quickly go through and thank again our distinguished panel, Sir William Blair, Pamela McDonald, Thomas Williams, Judge Sean Hagan, Christopher Grout, and Sheikha El Musnad. And we look forward to seeing you at another one of our events. Thank you so much, and have a good day or evening wherever you are. Bye-bye.